Second. Aye.
No.
There you go. And Jim, is your microphone on?
Okay. So just to. Uh-oh.
Yeah, ask Jim.
We approved the agenda, we approved the minutes, we opened for public comment, there is none, and now we go to new business, Board of Adjustment training, and the floor is to Mr. Michael Malachek.
Thank you. So we're going to keep it pretty informal tonight. I mean, I welcome your questions at any point, so feel free to interrupt. I am going to go through basically everything that was in your packet, each of the articles. Some of them are slightly out of date in terms of the state statute references, but the standards and I think the lessons in them are the most important. I'm going to highlight those. We'll have a couple of case studies for variances that we're going to go through, and then a couple of quasi-judicial discussion problems. And then the last item is a new variance decision tool that you're welcome to bring to any future board meetings. It basically has the state standards in a little chart, so you can mark things down when someone's presenting evidence. And that's one thing I'm working on. I'm skipping ahead a little bit, but I am planning to update a lot of the board materials like the variance chart, in addition to Chair Lemkis's scripts or the guides that you have. There's just a couple things that have changed with 160D, the new state land use law, and just some things that need updated. So anyway, that's the overview. So first, let's go through the first article, variance standards and unnecessary hardships. Obviously, this board's seeing a lot of variances coming before it, so I thought it was helpful that we review the standards. In this article, again, the state statute references are slightly outdated, but all the standards are the same. So again, granting a variance is allowed in limited circumstances. The mandatory standards in our ordinance basically apply, or sorry, the mandatory standards for granting a variance applies statewide. A couple things I want to highlight. A variance is not a free pass from town zoning regulations, and it's not a tool to work around our zoning codes. As with all quasi-judicial decisions, the applicant bears the burden of proving that they meet the standards to issue a variance. Merely showing inconvenience or just normal hardship that might be shared in the neighborhood is not sufficient to grant a variance. So let's go through the different standards, because this article breaks it down. So the first section, and if you want to follow along, I'm just on page 2, unnecessary hardship from the strict application of the ordinance. So again, anytime there is regulation, there are necessary hardships that are shared by all, having to adhere to setbacks, all of our other zoning code regulations. The difference for the variance applicant is they have to show above and beyond that their hardship is unnecessary and specific to their property. I guess to the next one. So again, a hardship has to be more than inconvenience or a preference to build something a certain way. Cost of compliance can be a factor, but is not enough alone, or is not a determinative piece of evidence. So it's not enough for an applicant say, to adhere to this setback, it's going to, cost me more for my to build my foundation. That normally is not enough to grant a variance. They have to show substantial hardship, and again, that the nature of that additional cost is different from others in the neighborhood. So let's say an example of that would be that if I have to build my house back into a hillside or off a steep slope because of our setbacks, I would have a cost analysis showing how expensive my foundation is going to be. That's not enough by itself. We need something to compare it to, which is the cost of a normal house or a normal foundation to establish the difference. So again, just showing that something's expensive is not enough. You have to show expensive as compared to what?
It would have the same expense, then that's just the way it is in the neighborhood. It's
That's
not a
right.
variance.
So if you're in a neighborhood and everyone's building on steep slopes, unfortunately, that's just what it is. Oh yeah, just jump in whenever. Sorry.
Microphone, please. And if I could just point out to everybody, Jeff Moore is now
Oh, I'm
on
sorry.
Zoom, so we might want to, let him in
My bad, talking.
and make sure that he can participate. Are you there, Jeff?
He's connecting. Hey Jeff, can you hear us?
His mic is off.
Yes, can you hear me? Hello,
Sorry, Jeff, you want to try saying something one more time? We're not getting any audio.
okay, can you hear me now? Can you hear me?
No,
That might be. We're not getting audio, Jeff, so if you do have a question, if you wouldn't mind just putting it in the chat until we can maybe work that out. Cool. Sorry. go ahead.
okay, so if we have a big development and everything's pretty much flat and there's one specific location where it's a steep slope, and if the setback requirements are 60 feet, if that would, as a variance, change to, they ask for a variance to change it to 40 feet because they can save $50,000 on the footing compared to all the other sites on that same development.
Yeah, and it doesn't even have to just be one lot. I mean, if it's a 50 lot subdivision and it's 5-7 lots that share that, and that's where unfortunately a lot of the interpretation falls to this board. What is common to the neighborhood? In my opinion, just looking at that example, I think 7 out of 50 is not common. But to your original question, do you have an opinion, Sue, about discussing past cases? I've always been advised not to discuss the facts of specific past cases.
I've been advised the same way. Once
Okay.
it's over, it's over.
Yeah.
Oh.
Yeah,
Fine.
similar
That's why
examples.
I
Yeah,
sort of general, but it's still a vote finally where you may say, that $40,000 is, what is that? And I may say, that's a lot of money. That's where you can have difference of voting. record.
and I encourage. Oh, yes. And I'd encourage that. Yeah, I mean, you should look at this body as a 5-judge panel. Every judge can issue their own opinion, if you will, and vote how you want. And that discussion, again, is what can lead to more evidence being in the record, people asking certain questions of an applicant that someone else might not have. Yeah.
Okay.
Okay. I'll be back, right? Okay. Sticking,
Oh, I have the chat up now. I'm sorry, go ahead.
okay, sticking with this 50 lot neighborhood.
Sure.
That has 7, let's say 7, let's go to 7. Not really level lots.
Mhm.
Would I be out of line asking the applicant, why did you buy this lot? You knew you were going to have a problem. Or is that being too judgmental?
It's not even being judgmental, it's just, and it will be coming up. The board can't have prejudice against someone for buying a property that they know they can't build on,
Okay,
but they know they could seek a variance for. So
See,
there's
that-
something, we'll get into self-created hardships later,
That doesn't seem fair.
And, well, because there's this option for zoning relief. You could even, it's even in the article, I don't think I will quote this line, but if Joe owns a property and he applied for a variance and was denied, if I have that knowledge and buy that same piece of property, I can come back for a variance for the exact same thing because I can produce different evidence that he did. So it's a different case that the board has to look at the facts presented before them every single time. So
Okay,
just that I know that there's an issue, that a building won't fit, that someone was denied before, that's not basis for denying or for questioning the applicant.
that makes sense.
So the next standard is what's peculiar to the property. So we kind of went into this already. So again, an unnecessary hardship has to be peculiar to the property in question, not general to the neighborhood. Usually it's location, size, lot shape, topography, water features, you know, if it's a stream setback or a pond. The example they give here, which I'll summarize briefly, is let's see. Oh, I'm sorry.
It's hard to keep up.
We were just talking today about someone managing. Hey, Jeff, can you hear us now? Where was I? So, yeah. So again, we already covered this, but if a property owner buys a lot, let's say is triangular in shape, extremely narrow at the front, and they know they won't be able to fit anything there because of the setbacks. That's something peculiar to the property, but it's not a basis for denying them that they bought it with that knowledge. Now, a self-created hardship would be, let's say I bought a regular piece of property, but I sold a third of it off to a neighboring landowner, and I created a small lot myself that I now cannot build within. That's a self-created hardship, where I do something to the property that creates the constraint or the peculiarity or something else. Yeah. I'm keep getting ahead of myself. So no self-created hardship. The thing they always say at the school of government is you can't shoot yourself in the foot and then ask for a variance. Now, one,
But
Yeah.
with that same example, this, I guess there's more different variants should come in. With that same example, I sold it to some other guy.
after
Yeah,
reducing the
I mean,
size.
you told me no because it's self, you
Mhm.
know, I did it to myself, so I'm like, okay, I'm out of here.
Mhm.
I sold it to Jimmy Joe here.
Mm.
He doesn't know.
Mhm.
He didn't do it. So he's coming for the variance.
Mhm.
So the fact that it's not self-inflicted, self-created, that means that he probably has a better chance of getting the variance.
Correct. Because he
Okay.
didn't take the action.
Right, I'm okay
Yeah.
with that. Okay.
And that kind of gets into the next point. So, what if a house was built, or what if someone invested in a house plan that doesn't comply with zoning rules, but because a zoning administrator issued an incorrect decision or issued a permit in a wrongful way, you know, ignoring the setbacks or something like that. If the owner or applicant shows that they relied on or had good faith effort to rely on, you know, what was permitted, they again have a case for a variance. Because as long as they show good faith effort, let's say the survey was incorrect, something along those lines, they have a case for a variance, and that's not self-created. And then we touched on this already too, but I'll just repeat it again. The act of purchasing property with the knowledge that circumstances exist that could justify the granting of a variance is not a self-created hardship. One piece of evidence that has not been presented to this board, at least while I've been here, are legal limitations on building. So restrictive covenants, HOA requirements. Usually, just like proximity or some of the other factors, they can't stand alone in granting the variance, but they can be a factor in it. So going back to one of the examples, if I have a lot size that's strangely shaped, or if I'm building on a steep slope, but my restrictive covenants require me to build a house of a certain size or in a certain manner, how it's directionally situated on the lot, presenting those covenants to this board and that requirement can also be proof of undue hardship.
But we cannot override a homeowners association agreement.
Correct. It can just be used as evidence.
Yeah.
Mhm. And then the last one is, purpose, spirit, purpose, intent of the ordinance such that public safety is secured and substantial justice is achieved. So again, when an ordinance, and that's why when people vary from the code, I always include that section of our zoning code for you all to look at. So you can do that review. When the ordinance expresses an intent or purpose, a variance should not go against that or subvert it. One example they give here that also gets into the public safety is, we only allow one freestanding sign per street frontage. But if there's a case, or if the sign ordinance says something, that the sign ordinance is in place to provide for adequate and effective signage and prevent driver confusion, perhaps based on the peculiarities of the lot or the site distances, another sign could be warranted here. Again, just in this example, but if for reason an additional sign would block driver visibility, that would interfere with public safety. So it gets complicated really quick, but that's where purpose and intent and public safety comes in. This I'm just going to quote straight from the article. So the statute requires the applicant show through the variance substantial justice is achieved. So what's substantial justice? Basically fairness in the community and to neighbors. So this concept echoes the requirement that hardship has to be peculiar to the property, not shared by the community. If everyone bears the hardship, one lucky person shouldn't be relieved through a variance. Similarly, the justice standard draws on the notion of precedence. So if Joe sought a variance last year because he had a steep slope at the back of his lot and was approved, and if Carl came forward for that exact same thing with the same type of evidence, because people can present different evidence, and the same type of lot, in theory, he should also be granted the variance.
But it's never the same evidence.
True. Yeah.
So it's always subjective how you interpret the evidence that's presented last year, and you may have different board members, and this year. So I circled this, essentially the same request essentially is very subjective.
No, I agree. I'm just stating that
If everything's the same.
if
yes,
everything's
then
the
it's math.
same, correct, yeah.
But wouldn't that burden be on the person, or the people that are trying to get the variance?
Yes,
Because you got a different committee, you got different people. We don't know what they did last year.
that's correct.
They would have to
And it's not
bring the
a,
proof.
and it's not a legally binding precedent like a court ruling. We're just diving into what is substantial justice, and that's just one thing you can look at.
If somebody in the same community had come before the board a year ago, 2 years ago, and was denied, and somebody was bringing pretty much the same case, would we know that? Would you know that?
No,
So we wouldn't know that they had been turned down before
No.
realistically.
and we don't do review, yeah, because again, each
mean, if they
case
can't- right.
stands on its own, yeah.
Okay.
Okay.
Yeah,
Let's continue on. Person one did not get his variance. No, person one did get his variance. And so then we go down the road and it's a year and a half later and person two comes and the lot is 98% the same. So it's the same. And can he state, person one got a variance, therefore I deserve to have a variance? Person number two can't just slide in on person one's coattails. Person number two still has to say it's because of this, 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 and this.
They still must present all the evidence to prove their case. If they did the research to show that there was another case like them that was approved, that could be presented as evidence. But again, it shouldn't stand alone as the deciding
Right, he just
factor.
can't come in and say, well, John got
Yeah.
it, therefore I get
And
it.
that's why I'm saying it's not a legally binding precedent. They can't say, oh, you did it for him, do it for me. Every applicant, again, it's like a court hearing. Every applicant, it's a new court hearing, and it's based on the evidence they present.
Right, because sometimes when a multifamily, a multi-home area is being opened up, and I see someone coming in and they want this variance, and all I can think of is we give it to them, and it's just gonna open the gates. But it does, but each person is a standalone request.
Mhm.
Is what- Okay,
If you
Yeah.
look
And we'll
at the
see
last
that.
sentence here,
where are you
the
at?
board must consider the issues on a case-by-case basis. They must
Mm-hmm.
weigh the evidence, apply the required statutory standards, and decide if the variance is warranted. That sort of summarizes the whole.
Right,
But if it's a new development, relatively new development, and I'm just piggybacking on what you said, would it be okay, or would it be prudent upon the developer to say, I have these plots, instead of me coming here 15 times, because all 15 of these homes will require the same variance. Can he come and say, I need to get one for these 15 plot lines?
Yeah, any property owner can apply to vary from any part of our code, including the subdivision ordinance. So in theory, if they had done that research and were ready to present that case at the front end, or were aware there would be an issue maybe for the properties they were selling, that's allowed, yeah.
Okay.
Again, with evidence presented to back
Right.
it up. So I think we touched all that. The last thing I'll say is no use variances are allowed. You can't vary permitted uses in our ordinance. New uses can only be allowed with special use permits. Different process. Any other questions about the hardship? We'll move on to the next article, quasi judicial evidence standards. We're getting a little deeper into the complex North Carolina case law. And this one focuses a little more on special use permits because evidence with special use permits can get much more complicated very quickly. Yeah, this blog post was just from March of this year regarding a case where the Court of Appeals had a ruling, again, March 1st of 22. So again, special use permits, they are zoning decisions like variances, but function like court cases. So in this ruling, the North Carolina Court of Appeals basically provide a reminder of the kinds of evidence necessary to approve or deny a special use permit. Also applies to other quasi judicial procedures like appeals and variances.
Let me ask you a simple question. What is the definition of special use permit? I'm gonna have a party, what's a special use permit versus a regular permit?
Off the top of my head, it's an application to request a development type or use that must demonstrate they meet specific standards as outlined in the ordinance.
Oh yeah, that was clear as mud, man. That was just. Why?
So let me do a quick review. So a zoning ordinance will have a list of permitted uses where those uses are permitted by right. They would submit a zoning permit application. I review it at the staff level and would approve or deny. Permitted by right. Then there's uses that are permitted with standards. One of ours would be a tiny home park, RV park. Or sorry, that's a bad one because that's special use permit. I can't think of one, but permitted with standards is basically still a staff level decision through a zoning permit, but there's additional standards the applicant has to meet beyond our landscaping ordinance, beyond our normal parking standards that apply to everything else. Let's just use tiny homes as an example and ignore that it's a special use permit process. For tiny homes, there might be additional buffering required. There might be different types of parking requirements because tiny homes, aren't true structures that are connected to the ground. They're similar to mobile homes where they're set up on a chassis. So different standards that are not written out in the zoning code for everything else would apply. Trash collection, community gathering spaces, etc. Special use permits go beyond that and take the decision out of the administration's hands or the staff's hands to a board. Minor special uses before the Board of Adjustment, major special uses before town council. And again, with those, the applicant must prove they meet specific standards as outlined in that part of the ordinance. So we're going up levels: permitted with standards, staff review. Permitted by right, staff review with normal standards. Permitted with standards, staff review with special standards that have to be shown. And then special use permits at the highest, being not permitted by right. You have to prove you meet these standards above and beyond everything else. Okay. Is that
A little bit. yeah.
okay? It's not easy stuff. So I think I just summarized actually the first paragraph. Probably should have just read it. So zoning ordinance treats uses as prohibited, allowed by right, or allowed with special standards or a special use permit. I'll just skip that page. Again, sorry. Oh, I'm sorry. I'm about to go to page 2. Because the standards for special use permits, and this is an important point, require analysis of evidence and judgment by the board. That's why the decision is in a quasi judicial setting. So myself as staff, I don't make decisions based on evidence where there's a lot of leeway for my judgment. That's why it goes before a board. That's why it's in the quasi judicial hearing. So the case that was ruled on is Dismas Charities versus Fayetteville. And basically this case came down to evidence allowed in the record. So again, in this ruling, the court confirmed that special uses are those permitted in the zoning district upon proof that certain facts and conditions as shown in the ordinance exist. They said again, when the ordinance, special uses are those where the ordinance expressly permits them in a designated zoning district upon proof that conditions in the ordinance exist or are met. So the board's role is to review evidence provided and assess the evidence against the legal requirements, whether the variance standards or the standards as outlined in the special use permit process. So to go through evidence proceedings, so again, the burden of evidence is always on the applicant first. And this goes again more to special use permits. The evidence has to be competent, material, and substantial, showing they meet the conditions. And again, the standard is that the evidence has to tend to show that they meet the standards. They don't have to prove beyond a reasonable doubt. And I'll just state too that remember that for variance cases too, because sometimes variance applicants could come in and just say, oh, this is going to cost more, or this is going to be hard for me to build this way. We need competent material and substantial evidence to prove that. I'm trying to do a better job with that by educating people at the front end, because again, most people aren't aware of what's required in these types of processes. So I've started handing out pamphlets in my emails for people asking about variances to make sure they're aware this is like a courtroom and they need to provide evidence to support what they want. So again, the article talks about, and I might be pronouncing this wrong, a scintilla of evidence, which basically means it is okay. There just needs to be enough evidence to tend to show they meet the standard.
So tend to show is enough.
According to this most recent court ruling. Okay. Once the applicant has met this burden of proof or evidence, the burden shifts to any opponents. Again, with special use permits. Now that there can be opponents to variances too. I think we've seen that before. But again, any opponents have to present their own material, competent, substantial evidence against the applicants, what they want. And then the most important thing, if no evidence is presented to counter the applicant's evidence, the applicant is entitled to the permit and the local government lacks the authority to deny it. So if the applicant in the board's judgment tends to show through what they've provided that they meet the standards as shown in our ordinance, they should receive the permit.
So if you take a vote and you accept the evidence presented, then you have to, as a board, vote in favor of approving.
No, because you can accept evidence into the record. That's a difficult question. You shouldn't, the board shouldn't argue against evidence, because you're correct. If you're accepting it into the record, you're acknowledging it's expert testimony. It's the board's decision, sorry, it's the board's role to deliberate if enough evidence is there that meets the standards. It's not the board's role to question expert evidence or testimony provided unless there is no expert.
Unless you have opposite experts with
Well,
contrary.
True. But I'm saying it's not the board's role to question an engineer or a builder.
No.
Yeah,
Yeah. But my point is that if you get this, sometimes what I've seen, we vote and we vote, yeah, that's accepted, that condition is accepted. And then we come to the final vote to approve the whatever application. And then some people vote no.
I see. I misunderstood you.
Okay,
You're talking about voting for that the standards are met.
yes.
Got it.
So I think that's where we gotta probably learn how this should work.
If you vote, yeah, if you vote that the standards have been met, you must vote. I mean, it's your legal duty to vote to issue the permit.
See, and that's what I think we need to,
It isn't happening. It's not happening. You know, thinking of a very major case we've had over the last year where things are presented and then some people think that they were presented properly and they believe in it, and other board members aren't comfortable with the way it was presented. And so they vote no, as opposed to yes. Yet we're all hearing the same evidence. And I heard you say a while ago, it's perfectly all right for all five of us to have five different opinions.
And I'm agreeing with that. When you're voting on, let's just take the variance, for example, when you're voting on the four standards, the vote for each standard can be split. I'm just stating if the board as a whole has for the variance, the 4/5 majority approving each standard, the variance should be approved. For a special
yeah.
use permit, it would be the simple majority. If there's a simple majority approving or stating each standard is met by the applicant, the permit should be issued. And again, and that's where Board of Adjustments don't get enough credit, because these can lead to serious legal issues and costs, for the town, for applicants, for others in the community. If those rules aren't followed, there could be legal consequences on both sides, variances and special use permits.
Let me go back and ask a question of what you said. So one side is going to present evidence. And you said, I thought you said that the board cannot challenge that evidence.
The board can interpret whether the evidence, one, is acceptable as material competent expert testimony. But once let's say it's a traffic engineer, the board shouldn't argue with an engineer, with a builder, that is showing his credentials,
But what if
that
his
his interpretation's incorrect.
But what if the argument is garbage? Just because you have an engineering degree don't mean that that's garbage, what he's saying.
Unfortunately, it's not the board's role to question that. It's to an opposing member of the public.
So we still accept that as evidence in the record. Then we vote on the 4 conditions that have to be filled, and then you can speak your mind again in that vote.
I don't know.
I have a question, but maybe a clarification. It says, once the applicant brings in his presentation, so the burden shifts to any opponents. So if somebody comes in and there's no opponents, but, we're thinking, this is just not right. We can't question because there's no opponent got the word and showed up to, there might be an opposition to it.
I mean, that's right. The board, I'm probably restating what I've already said, but the board's role is to interpret if the evidence has met the standards. It's always going back to the ordinance. And that's what I tell people every day, even when I give people bad news that something's not allowed. I just apply the language that's in the book. And that's this board's job as well. But it's not within the board's, I forgot your question now. Say that again.
Well, I'm saying if they come in with the evidence and we may have the ordinance right in front of us and we know the evidence
But
they
there's
are
no opposition.
presenting is not in keeping with the ordinance, we can't question it all. Huh?
Well, but that's, it depends on the standards. If it's a variance and if it's not within the spirit, purpose, intent of the ordinance, that's something you can rule on and state it doesn't meet that standard, and that's a reason to deny. But if I heard you correctly, if there's no opposing party submitting opposing evidence, there's nothing else for this board to consider. It's not the board's role to come up with contradictory evidence. You're just the judge. You don't produce evidence. You just rule what's presented, rule on what's presented.
But if I understand the question
Yeah.
correct, it says entitled to the permit. The applicant is entitled to the permit.
If they've met the standards. So if the applicant,
It's not what it says. If no evidence is presented to counter the applicant's evidence, then the applicant is entitled to the permit.
Once the applicant has met the burden.
but
Once the applicant has met the burden,
yeah,
you have to decide whether you
Whether they
accept all
met
this
the burden.
evidence, then you have to decide whether it's sufficient.
Yeah, Sue, you're right.
and it just follows point 1. Again, it's just point 1 to point 2. Point 1 says, as long as they have evidence tending to show they meet the conditions.
So we do have the ability to, the word question isn't right, but to challenge the evidence. We have a person with a degree and he is a state certified whatever, and presents it. So we know that it's not just Joe Blow off the corner. And he presents the evidence, and if we're not comfortable with the evidence that he presents, we don't have to blindly accept it. We can state that his evidence, in our opinion, did not meet the burden of proof.
If you're saying it doesn't meet the burden of proof, that's one thing. If you're challenging what he's presenting to you, I would say the best course of action in your role would be to ask clarifying questions. Question all you want, but if they're an expert with a doctorate or a
Right.
master's degree in whatever their field is, and if you feel they're an expert witness, it should be accepted. I know it's a gray area and a fine line, but I guess all I'm trying to say is ask as many clarifying questions as you want. That's why they're up there, why we're sworn witnesses, why we're up on the stand, if you will. So probe all you want, but once they've given their testimony and once they've presented their evidence, it's a fine line. In my professional opinion, it's not in the board's role to question their methodology or results.
It's our duty to interpret evidence presented if that fills the four conditions for a variance and a special use permit, whatever.
Correct. It always goes back to what's in the ordinance book, either the four variance standards or the special use permit standards.
Well, of course, it says right here, note that the standard is that the evidence tends to show and not proves. So it doesn't have to be sealed in stone.
Doesn't have to be absolute.
So you,
Hey, Mike, this is Jeff. Can you hear me?
certain amount of leeway you have in your vote. Does this evidence make it whatever? Is is it contributing to the purpose, public safety and substantial justice, blah, blah, blah? Yes or no? If you feel, yeah, it's good evidence, but it doesn't really fill that condition, you vote no. Yeah, that freedom obligation we have. It's not math.
And you can also challenge whether it is expert. If it's me building a house and I just tell you it's gonna cost me 10,000 more to build because of this, but I don't provide
That's not
That's
expert.
an
not-
engineer, well, exactly, and that's why I'm just expanding on that. You can't question that.
You can question the homeowner. You can say, how did you come up with your
The non, yeah,
$10,000?
the, what you would deem non-expert.
Mhm.
That's an opinion.
Yeah,
Hey, this is Jeff. Can y'all hear me?
Can't question the expert.
Hello?
well,
Hey,
You
this is
cannot
Jeff.
question the expert's authority. You can put questions for the expert.
or you
That's fine.
could ask them to explain so that I can understand better how you came up with that traffic count.
I encourage you,
Something like that.
yeah, I encourage you to question them, probe them, to get what, because the more you question, the more testimony they give, the more evidence you have to base your decision off of. So I encourage that. But if they deliver a report saying it costs this to build a foundation, or this is the traffic generated, you can ask about their methodology, but you can't say, well, that's wrong. Or I don't
Fair
believe
enough.
that. Yeah,
Because you will, the challenge is not when you have the applicant presenting or having evidence presented by an expert witness. The challenge comes when you have contrary evidence presented by the opponent, by an expert witness. And the one says A and the other one says B. Which we've seen in
Mhm.
our.
Oh, yes. But then we have the option. Each one of us is saying, I feel more comfortable and I believe expert witness B. I think expert witness A shade the corners a little, in my opinion. I'm not saying I'm stating that for record. I'm stating that in my mental thing, because he has his certificate, he has his college degree. She has her certificate and her college degree. Therefore, they are equal expert witnesses. You know, they have the same number of years' experience, the whole deal. So then it's just which one presents their case better to us is how we do vote, right?
yeah.
Yeah. But we have to have two expert witnesses.
If you were talking about opposing it,
Yeah, we can't
Yeah.
have expert witness and Mr. Homeowner.
correct. And that's the next article.
Hey, this is
Going-
Jeff. Can y'all
going
hear me this
this
time?
one up. So in this case, I'll just summarize quickly. This actually
Michael,
goes
this
into a case, in the recent court decision, they cited a case that the city of Asheville had in denying a permit. And basically during the hearing, the city council of Asheville questioned the assumptions on which the applicant's experts based their opinions and methodology used. And they had members of the public express concerns about the special use permit, but no testimony was given to counter the applicant. And again, just like we talked about, and to summarize, because the applicant produced competent material, substantial evidence to satisfy the standards, and because no other evidence was offered, city council lacked the authority, in this case Asheville, to deny the permit. So again, that just summarizes what we already said.
Hey, this is Jeff. Can y'all hear me?
This is important too. So, and this was highlighted in this case. So any standard to which an applicant is held must be reflected or supported by the relevant ordinance language. So if we want to hold applicants for not variances, because those are set state standards, but for special use permits to a higher standard, or if we want additional standards, the ordinance language has to change. And again, that gets into quasi judicial proceedings and due process rights. When an owner looks at our zoning ordinance and sees the standards laid out, they're notified they have to meet those in order to get that use granted. No additional standards can just be conjured up that they would have to meet. Okay. Here we go. How we going? Sorry, Jeff. And again, just to summarize, I think we've already said this, and this was in the court decision, applicants are not required to negate every possible objection to the proposed use. And I'm sorry, let me take 30 seconds to make sure Jeff's working here.
Hey, this is Jeff. Can y'all hear me this time?
Hey, Jeff, are you able to hear us and speak?
Can you hear me? I'm trying.
I still can't hear you for some reason. It must be my end, but I am monitoring the chat. So if you have a question, you can type it in. No, you're fine. I'm going to basically skip through the rest of this. I'm on the last page of that second article now. But again, just to summarize and also to speak to my job as a staff person trying to educate the public. Whenever quasi-judicial decisions are made, boards and community members should be reminded the decision has to be based on evidence. Boards cannot be swayed in quasi-judicial matters by popularity and public opinion, or question them solely whether there is sufficient evidence. Or sorry, the question before the board is solely whether there is sufficient evidence to show the standards will or will not be met. This kind of clarification is helpful in communities that do not often encounter quasi-judicial hearings and may be disappointed by the approval of an unpopular use that nonetheless qualifies for quasi-judicial permit entitlement. And I think that speaks to our role. Because again, I've only been with the town 10, 11 months, and I know in the past, there have been fewer of these quasi-judicial cases coming before you. But I will tell you, there will be more, and it's just that development is coming and is here. So again, my job is to try and educate the public and the applicants about what is required of them when they come before this board for a variance or a minor special use permit. Again, if we want higher standards, we have to check the wording of our ordinance and make sure our ordinance standards ask for the conditions and community-specific circumstances you want an application to address.
That's very important on your side.
Those ordinance, easy for me to say, those ordinances would be something that town council would write, wouldn't it?
Oh, the ordinance.
The ordinance itself is something that town council.
Hey, this is Jeff. Can you hear me?
One second.
Hey, Jeff, we're working
Hey
on
there.
get you where we can hear you.
Jeff, just keep
Okay.
talking.
Okay, I'll keep talking. Hello? Can you hear me yet? How about now?
Hey!
Hey, you got me.
Talk quickly.
Oh,
Go ahead, Jeff.
Okay, the Asheville case that was mentioned, I happened to be there. I was the city traffic engineer at the time. And a friend of mine who later became my boss did the traffic study. And he explained that the traffic study was done in accordance with nationally accepted procedures and guidelines, et cetera, and that it did have a third-party review by the NCDOT. But one of the people that spoke against the project mentioned a blind curve on one of the roads that led to it. And so council started asking questions about the blind curve. Well, there was no evidence that that curve was a blind curve. It was not studied. It was not in the scope of the traffic study. There was no evidence presented that there was a safety hazard, et cetera, et cetera. But from my perspective, sitting there, it seemed like that is one of the reasons that council denied it, was that they said the traffic study was inadequate, and yet it met the standards that were written in the UDO. So if I remember correctly, that's one of the reasons that it was overturned, that they were questioning the evidence, and yet the evidence met the standards that it was supposed to meet. It met the ordinance. So yeah, that was quite a shock when that project was denied. And but they took it to court and won. So that was just my perspective on that case. I have been questioned as a traffic engineer about my credentials, and I'm able to produce, where I went to school, that I am licensed, et cetera. And I've been questioned about methodologies. And as long as I follow the standards, and then my work is reviewed by NCDOT, so there's a third-party review, then that's accepted as evidence usually.
Thanks, Jeff. Great clarification.
But yeah, that was quite a meeting. That was a very long meeting, and we were there.
Yeah, we know those.
So let's go move on to the next topic, which is standing and quasi judicial hearings. I'll go through this one a little quicker. But again, feel free to jump in with questions. So again, the main decision here, or the main point to distinguish, is the difference between participating in a quasi judicial hearing and having legal standing in a quasi judicial hearing. So let's go over the participation part first. I'm on the second page. It's necessary to separate two related but separate issues: the ability of an individual to participate in the hearing and the rights of an individual to act as a party with legal standing. Many individuals participate in the hearing without standing. Consider a special use permit. So me, as planning staff, introducing an application providing staff analysis against the comprehensive plan and other analysis of the project meeting our ordinances, that's just evidence. I don't have legal standing, but again, I provide analysis for the board to consider and evidence into the record, usually the application and everything that's been submitted ahead of the hearing. But I don't have the right to cross-examine a witness like a party with standing does. So the applicant, obviously, or the property owner in question, they have standing as the applicant. They can call witnesses or experts to testify, but again, their experts don't have standing. The traffic engineer doesn't have the right to cross-examine a witness or object to evidence submitted into the record by another party. They just provide evidence and testimony for the applicant who has standing. One important point: the board is not required to hear from those individuals without standing, including the public just wanting to give general public comment, but the board can allow individuals to provide evidence on the matter. It just can't be considered in the decision. And again, another fine line. I know in the town, and again, my short time here, it's the general practice to allow public comment on these matters. And I'd say that's fine. And I think the way we do it is good because it's clearly separated. and it's stated that this is, and I would even go so far, and this is where I'll look through some of the scripts for the chair, that when giving public comment, it's allowed, but it's not going to be considered as evidence of the decision. I think even just stating that educates the public, educates the people coming before the board or council for whatever special use permit or decision is before them.
I
Public,
don't think it specifically says that on there.
Maybe we should.
That's what I'm saying. That's the kind of stuff
Yeah.
I'm going to look at.
but public comment does not become part of the minutes. Or does it?
We're not required to put it in there. If someone hands us a written statement, we'll attach it. Otherwise, all we have to do is say public comment was given.
Okay.
We usually are a little more courteous and we say, this is, so-and-so spoke. If we have an address, we include it. And then in favor or against.
But I really would appreciate that on that check sheet. It gets longer and longer, but it does keep things in a logical form.
I hear you.
And a fair form. This is new to an awful lot of people. I mentioned a while back, oh, I can't have dinner with you tonight. I'm going to a Board of Adjustment meeting. And they're like, huh? And people, I don't think people understand. As you've said, people even coming to want to come to the meeting, they don't. So I think your idea of educating everyone is a really good one.
And it is, and it's just based on similar circumstances I've seen with people, I have to deny people on a weekly basis because they don't meet the rules, or they may not even know there are rules. And some of them are just like, well, how can I get this to work? It's my responsibility to offer a variance as an option, which I will admit may have resulted in more variances before this board, but it's something that's legally allowed under the code. But what I'm trying to get people to understand is that it's not just another something you pay for and you get your permit. It's a process, it's a courtroom-like hearing, et cetera. And that's what I'm going to try and reflect in those documents and interactions with the public.
So let's go back to who has standing. So
Yeah,
obviously the person that's attempting to get the variance has standing,
correct.
but his neighbors have no standing.
Let me read this next section. So relatively few individuals have legal standing in the quasi judicial matter. A party with standing is obviously the applicant or the property owner for the subject property, but also an aggrieved party that would suffer special damages from the outcome of the matter. They are distinct from the general public and enjoy certain due process rights that must be protected, just like the applicant. And then there's a general statute for that. Now, this one in the article is wrong. It's 160D 1403 currently after the state land use law updates. But it outlines the rights and procedures for appealing and sets forth these standards for having standing to appeal. 160D 1403. Nope. So, and again, it just says this guidance is instructive for determining standing. So one option is a person with a legal interest in the subject property. So could be the owner, could be a leaser, could be a person with a letter of intent to purchase or under contract, et cetera. The applicant, obviously. The town has standing, especially if a governing board or council believes a decision was made in error, council can appeal a decision because as this town, they have standing. And then in this specific instance, we're talking about a person who will suffer special damages as a result of the decision, or another one is an association organized to promote the interests of a particular area, HOA, community association, neighborhood association, as long as one member of the association can prove standing, and the association can't be created in response to the application. So I can't apply for a special use permit to build 500 townhomes, and then all of a sudden, South Mills River Neighborhood Association pops up and they want standing. That's not legal.
But if they had been in existence for quite a while,
Correct.
conceivably they would.
Yes, yes,
So the dog club from 1950
yep.
is still.
Or just a neighbor, or again, a person who will suffer special damages, and that's what we'll get into next.
This can make pretty loud meetings with public comment who don't really have standing.
Say that again?
They
Pretty
can make
loud.
for a very loud meeting with the public who don't really have standing and really don't understand that they don't have standing, and you're making me basically ignore them. Just they don't have standing and making a ruling based on evidence.
State law makes you ignore them.
Well, that's why we
Yes.
give them the opportunity to speak their mind before the actual hearing starts. I don't know where that is. Is it before the public hearing starts?
It's towards the beginning.
Right now, in your procedure, you allow it during the hearing, but you don't have to. It is something our attorney has said that maybe you let all those people speak before you get into the hearing. So it, in your mind, completely separates it.
I think that'd be good.
And then they cannot comment on the evidence that you get.
That makes sense.
But you're right. I mean, it does introduce more,
More noise.
and as the legal term is, lay person opinions, or it's actually considered hearsay testimony because it's not based on evidence.
Right. Understand that.
Into the hearing, yeah. So again, a party that has standings is allowed to cross-examine witnesses, can object to evidence, can offer rebuttal testimony, and can challenge the impartiality of a decision maker, being one of the board members, and they can appeal. Mere participation in the hearing does not establish legal standing. So, and this is where it gets tricky. When is standing determined and by whom? So we just talked about this. Standing should be addressed in advance of the action. So the decision that the applicant is seeking. Usually an individual has to offer evidence to prove they have standing, to prove they are suffering a special damage beyond, similar to like we talked about the variance, beyond what the general public will experience, that they are adversely impacted. So the board can hear that evidence and rule it on the standing. Now, if you have a member of the public who's giving public comment and they may start to make arguments for standing, the board has the authority to stop them and basically ask them to make their case for standing. If they want to be, if a member of the public gets up and says that traffic engineer is wrong, I'm going to challenge you, et cetera, that's not allowed, but the person could be allowed. Basically, just ask the question, prove you have standing.
We have to vote on that.
Yes. You have.
So we would have to, somebody would have to make a motion to give James standing on this.
After they present the evidence to show you they have it. And that's what's coming next. So in one of the special North Carolina court cases, I'm on page 4 now, I think, proving special damages. So in this case, an application asked a neighbor to explain how she was an aggrieved party. The neighbor stated she was a resident, and again, this is just a particular case. We don't have to get into the details, but she was a resident adjacent to a subject property for a special use permit. Her house that the house proposed was not in keeping with the neighborhood and would harm neighborhood property values. This court ruled that evidence was not sufficient to establish standing. So what is sufficient? Case law hasn't established that. Isn't that a great answer? There is no case law that has established a clear rule for establishing standing. Each case is a fact-specific inquiry based on a set of factors, including the following. And I can include this in, a packet on standing that we can have in that guide. So the set of factors for standing include proximity to the subject property, property value impacts, and other adverse impacts.
which is exactly what she was saying.
But you have to prove that with evidence.
Right.
For example, Linda, she's standing there saying, it's
I-
going to affect my property value. If she had an appraiser there with her or brought in an appraisal or something, then she has evidence.
Mhm.
The party who claims standing has to show their damages are distinct from the damages of the public at large. So again, similar to the variance, why is this person special? Why are they adversely impacted beyond everyone else? And that they should get standing and get all these due process rights in the hearing. So while proximity is in and of itself is insufficient to grant standing, it does bear some weight. Property value is one. I'm just going forward a little more quickly now. Property value is a factor, but not determinative in and of itself. Even with an affidavit from an appraiser showing a loss of value, that alone, again, it's based on the board's interpretation, can be insufficient without identifying secondary impacts. And they list traffic impacts, noise impacts, light impacts, odors, stormwater runoff, or other potential damages generated by the use. These additional adverse impacts have to be shown by the party alleging standing. In order to establish standing, the individual must do more than state that they live in the area and they state the project will hurt them. That's not enough. There has to be evidence and they have to allege secondary impacts.
And that evidence has to be presented by an expert.
Yes, it has to be expert material, competent evidence. But they would present that as part of their appeal to the board for standing. And so it's almost like a mini court case in a court case. And it's the board's role to vote, like you said, on whether that evidence meets these guiding factors and whether they should have standing. Easy, right? But those are things that I think are important because it isn't, North Carolina case law doesn't say this is it, this is what should be followed, but it's guidance and that's stuff that I'll reflect in those.
Almost want a flow schedule
Mhm.
of the different steps. And if this, yes, then that way or that way. Have fun.
So again, the essential element for standing is that the board sees a credible allegation of harm to the use and enjoyment of personal property.
So even if we would have if there's a motion to give James standing and 2 vote in favor and 3 vote against, then you got no standing. Right?
I would say 2.
2 and 3.
2 and 3.
Is it a simple majority or?
Yeah, I'd have to look at that specifically to get that answer. Even if it's standing.
So I have a question.
Yeah.
So hypothetically, someone comes in and wants a variance for the use of their property, conditional use, thank you. Feel free to jump in when memory fits. And so they come in asking us for that conditional use. And then all these other people come in, I guess, saying that, you know, against it. But I don't recall us ever even deciding whether or not they had that position that they standing. So is that automatic, like when it gets filed? I mean, I just don't,
Is standing automatic?
yes, like
No.
in that, so in the hypothetically, all these neighbors came in with their evidence of, you know, sound, whatever, but I don't recall us ever even discussing if they had standing.
I know what you're
Is that-
talking about.
Do you know, so do we have to
Um,
do that? Or is that an automatic? Like, where does that come into the whole situation?
Legally, standing should be decided in the hearing. Or else you're infringing on the applicant's rights, because if you're giving someone a chance to challenge the applicant and you haven't even recognized that person or made them prove beyond or
Right,
with
but we didn't-
evidence that they're on the same level as the applicant,
But I don't, is that even in our thing? I mean, like, we didn't do that in that case. So is that something that we should be doing before?
she said in this example, the attorney would ask for that.
Understanding?
Yes,
Okay.
I don't know.
Yeah,
Right,
that's-
right, I
I-
understand. So
yeah.
let's
Yeah.
pretend the attorney is here,
Yep,
okay, and Joe Schmo wants to build a doghouse, it's
Yep.
not allowed, comes with
Mhm.
additional use. And the neighbors say, we don't allow dog, it's not in their POA, with HOA. But the neighbors come, there isn't an attorney. Do they automatically have standing?
No.
Is there some, like, so then are we supposed to decide?
Yes.
Okay.
the decision on standing must be made by the board.
And is that before we even allow them to present evidence or speak, or like, how would that work?
The timing can be flexible. I think it's best, like we talked about, to have it earlier in the hearing. But as one of these cases stated, as long as it's before the decision, as long as it's before evidence is closed, it's allowed.
So do we ever have to acknowledge and say they have standing?
Yes. Because if you're just letting some member of the public, even if they live right next door, even if they're saying this is going to impact me, if they don't have evidence, you're basically allowing them
Right.
to the applicant's level, but the applicant's held to all these standards and this member of the public's not. So you're actually infringing on the applicant's due process rights and they have a case for a legal challenge.
So even, okay, so the first thing we got to decide is, does the opponent have standing?
Correct.
Then next is it the opponent's opinion or is it expert witness?
Correct. So they have to present evidence to prove they have standing. Then they have to present evidence against the applicant's evidence.
Right.
That is
So be,
a wit, like, isn't just their opinion as substance.
Yep. And that's why you often see attorneys hired for that.
Well,
so this is almost like when we start, and we're swearing in people that's going to talk and provide evidence. Think about this almost as if there is going to be opposition that we almost need to ask who the opposition people, who are they and do they have standing before we start this thing, almost like after you swear in.
I agree. And I think that's something we should build into the process and what I'm advocating for too. Even
Right.
if
Who
you
are you?
welcome public comment on an issue,
Right.
just from members of the public. And again, that's something I can build in for the chairman, is a statement saying, this is general public comment. This is not evidence to be considered,
Right.
but if someone would like to apply for standing to
Now's the time,
to
right?
go through those things, to counter the applicant, challenge, et cetera, please do so, we can call for that.
well,
I'm all.
But for example, and I obviously could be wrong, but I don't, so let's pretend that in my doghouse suggestion, right? So 4 of them are represented by the attorney. They have standing. If it's been established by the attorney that those 4 people, and we say, okay, yes, and that person has standing. But when the neighbor on the other side, who's not represented, but still falls into the neighbor group, if that neighbor goes to speak, that neighbor doesn't automatically have standing based on, correct?
Correct, yeah. Unless, you could in theory still present evidence on your own to prove you have standing as an individual without an attorney.
But what I'm saying is, those 5 people
Mhm.
have their attorney as a
Mhm.
group. We've established whatever those 5 people say, theoretically, they have standing. And then the other person says, well, I live on the other side, not involved. We still have to then determine that that person has standing. They can still speak during the non-whatever comments, but for them to really say anything that we're going to weigh or consider, we have to determine that that person has standing first.
Yes. To have evidence that's weighed in the record.
So as I'm hearing all this, I'm just thinking of the nature of our hearings generally are applicant versus city regulations, town regulations, let's call it.
Mhm.
It's not applicant versus neighbor. Whereas, but these folks that are coming over here are thinking that they can come and debate whether this person gets it or not. So there's going to be some very unhappy people, and I think there's going to be a lot more of these as you see all these developments coming along.
One of the things though, Linda, when they receive a letter noticing them,
Okay,
and when the ad is published, it specifically states that they need to have, if they want to present evidence, to contact us so we can make arrangements, to make sure that they're available. But we're very specific that they have to have evidence.
And that's a good point, because we didn't talk about public notices, but that's again, another opportunity where we can beef up that education.
yeah,
And again, obviously, just what we've gone through tonight, it's complicated topics.
and we want to be fair to everyone.
Mhm.
And that's one of the joys and one of the non-joys of a small town, seriously. But a lot of these folks come thinking they're going to have their day in a quasi court, and they're not getting it. And then they do leave a little unhappy.
We haven't really approached it that way yet. This standing thing is something, an added issue. We've been dealing with evidence or opinion more before than just a combination of standing and evidence. So my question is, if I do not live close by, what is all the conditions? I'm an expert witness and I say, this project is terrible and I'm an engineer, whatever, and it's gonna be a lot of noise. But I live 6 miles away.
You don't have standing.
I don't have standing.
Proximity is not always it can't always be the sole deciding factor, but it's very important. Because to prove you have standing, you have to prove those special damages beyond anyone else in the neighborhood. I don't know how you do that 6 miles away.
But that person could speak during public comment.
Yeah.
We just need to know. where they're coming from.
We need to get for me, that's new standing. Not totally, but we need to get a little bit more specific criteria.
Mhm.
So we can learn how to consider that and then vote on it.
Mhm.
Then we go on, and then maybe some people feed off that they didn't get standing vote.
Mhm.
Well, I'm sorry.
I hear you. Yeah.
And to be fair, for some of these standards have been updated through time. Other trainings we've had, nobody mentioned standing. None of our attorneys have mentioned standing, but all of these statutes have been rewritten. And the development, the
160D.
training
Oh.
at the School of Government has gotten more sophisticated as well.
That's fine.
You've been
We
on here,
learn.
you've been on here as long as I have, 19 years. We've never thought about it.
Any other questions? We're through the articles. I've I know it's getting a little late. I wanted to go through some of the case studies.
Okay.
So let's go through some of the variance ones. These are somewhat more simple, and I think shouldn't take that long. So Lot A. So Lot A is an empty lot in an existing neighborhood. It's a deep lot and the topography slopes dramatically from the road down to a stream near the back of the property. In order to preserve the low density character of the neighborhood, the front yard setback is 60 feet. Because of the topography, though, a setback of 60 feet would leave Owen, the property owner, with only a narrow 15 feet of buildable area between the front yard setback and the floodplain. Owen has requested a variance to allow a setback of 40 feet front yard setback, which would be a variance of 20. Can he make a case for a variance? Why or why not?
Yes.
Because it's not a problem that was created by him.
Yep.
Because of topography.
Yeah, because of conditions peculiar to his property, topography being one of them. Great.
So then all the other conditions, you just have to vote yes.
Sorry for the variance.
Because that, it's not
Yeah.
just that one.
But there's the. You don't have to vote yes on all of them. You have to consider each one.
Okay.
Yeah,
Yes.
and again,
legally,
these are just high level questions to just touch on some of the
Yes.
things we went through in the
Okay.
articles.
Oh, yeah. Here you go.
So Lot B. Lot B is located in a block of residential houses along a busy corridor. Through the years, as the nearby hospital has grown and the corridor has gotten busier, many of the homes are converted to medical offices and commercial uses. 5 years ago, the town rezoned many of the parcels to commercial office. The initial proposed zoning maps did not include Mr. Owen's Lot B property. At the time, Mr. Owen told the town planner he would like his property to be included in the rezoning. The planner agreed, saying the lot should have been included from the start. The final zoning map the town voted on did not rezone Owen's lot. It remained zoned for residential. The rest were rezoned for commercial. He continued to rent the property as a single-family home. Last month, he was approached by a medical group asking to rent the house for offices. That's when he learned the property was not rezoned to commercial, but it exists as residential zoning. He argues the property is subject to unique hardship. All the neighbors are zoned commercial and the nature of the area is commercial. What's more, it was caused by a mistake by the town. He even pulled out the old email from the planner saying the property should have been rezoned to residential. Can he make a case for a variance?
Yes.
Yeah, make it, yeah.
No.
No. You've been renting it, now all of a sudden you get more money, that's why you ask.
Tell me why no.
The reason it's no is because it would be a use variance. So remember, we can only vary regulations as it pertains to dimensional requirements, whether it be subdivision road right of ways or setbacks across an entire subdivision or individual lots. A variance can't vary a permitted use. So he's saying, I want a commercial medical office to come into my property, but he's zoned for residential.
So
Even if it was a town mistake, a variance can't change zoning and can't
Okay,
change
got it.
uses.
So what was his option be? What was the town-
Can he go for a special use permit?
Well, what was his option be? Go back and get a special use permit or get the,
If this gets into details, but if the residential zoning ordinance allowed special uses for office, sure, he could apply for one. But he should really just seek a rezoning. It's,
or go.
and again, remember, rezonings have mailed notices too. So in theory, he received a letter, and if he didn't check that his property was not included, that's kind of on him.
Okay, so bottom line is this would never come to the Board of Adjustment because you would turn it down. First place.
Yes, my point with this was just to,
You would move it elsewhere.
Yeah.
You would tell the person that it needs to
Good job. Good job.
a rezoning
not-
or a
That is
special
out
use
here by
permit if it
11.
was allowed. But the point with that exercise is just to show we can vary dimensional requirements as outlined in the ordinance. We can't vary permitted uses. Lot C. Lot C is an empty lot in an existing neighborhood. In order to preserve the character of neighborhoods like this, building height limits of the district are based on a calculation of the width of the lot. All lots in the neighborhood are narrow by current standards. Mr. Owen's lot is uniquely narrow because a couple of years ago, he sold a narrow sliver of land to his neighbor. He's ready to build a house. He's drawn up designs, but he learned the design's too tall. He wants a 25-foot building, but because of the narrow width and because heights are calculated based on your lot width, he can only build a 17-foot tall house. He wants a variance. Houses on his block are taller. Can he make a case? No.
He sold it. I mean, it was
Self-inflicted.
Because he created the lot.
right.
Ding ding, self-created hardship, not allowed for a variance. Good job. Lot D. Lot D is an empty 1 acre lot located on the edge of town in an area developed with very low density back in the 70s and 80s. Mr. Owen wants to construct a single family home. The zoning ordinance prohibits well and septic systems for new development in the town. New development has to connect to public water and sewer. Owen is convinced that the chemicals in public water lead to cancer, so he doesn't want to connect to public water. Additionally, the water authority had advised the nearest water and sewer is over 2,000 and 4,000 feet away respectively. The required connections would cost approximately $1.2 million. Owen wants a variance to allow him to construct a individual well and septic system for the single family home. He has approval from the county health department that it's possible on the lot with the soils available. Can he make a case for a variance? Why or why not?
Single family home?
One single family home.
1.2 million. I would think he would. That cost it would be unreasonable.
He hasn't done
The lot has stood empty since it was so.
Correct.
It's a little weird.
Yeah.
You know, but if that expert witness says 1.2 million, I would say, yes.
Sure.
And I-
had the variance.
And I think that's the point. If I were to dig into it, you wouldn't want to accept testimony about public water causing
No.
something not based on fact. But if he has an engineer stating that cost would be a burden to him, then yeah, he has a case. All right, moving along, Lot E. Lot E is a 10-acre tract in town. Mr. Owens proposed a subdivision for 15 lots of single-family homes. The town wants to encourage this type of infill development. He wants to apply for a subdivision variance for the road right-of-way width. He has engineers' drawings showing the topography of the site makes it difficult to have a 45-foot right-of-way and get 15 buildable residential lots. He wants to reduce the right-of-way to a minimum subdivision standard of 30 feet due to the steep slopes, a 15-foot variance from the ordinance requirement. Can he get a variance? Why or why not?
Wouldn't this be more a rezoning type thing? Because we've already established a variance has to do with setbacks and style.
Right-of-way can be included because the way I define a variance or what's most commonly asked to vary are dimensional
True.
requirements. And again, like we talked about with the example before with the subdivision developer getting a variance at the front end for the whole subdivision, again, for lot setbacks, that could apply to other requirements.
So, yes.
Yeah, I think it's a gray area. Again, these are just simple cases. Without evidence, we wouldn't really know. I think as long as he shows topography is unique to his 15 lot site and not others around him, I think there could be a case, but it would really depend on the evidence in the record. And remember, this board doesn't have to accept, here he's asking for a 15-foot variance, basically decreasing the right of way by a third. This board doesn't have to accept that. If you determine based on evidence in the record that, it should be 35 feet, maybe it's 40 feet, maybe only a 5-foot reduction. Again, based on the evidence, you can modify what is granted. So last one for variance is Lot F, a residential lot with a small house. Back in '03, the property owner requested a variance to encroach into the rear yard setbacks to expand his house. The Board of Adjustment denied the variance request. Last year, Mr. Owen bought the house with plans to expand the back of the house as well. He knew when he purchased the lot, he would need a variance in order to accomplish the expansion. Can he seek a variance? Why or why not?
Yes, because he
Yes.
may have new evidence. We should better-
Yep. Great.
Let me ask you a question
Yeah.
that I was curious about. What is the, I guess, what's the right word, legal financial liability of this board individually?
Good question. We should probably talk to your attorney
I mean,
about that.
how much
Um,
exposure, you made a decision that somebody didn't like,
Mhm.
for whatever reason. How much exposure are individual board members risk are at
Sue's about
when
to
the guy
press her
sues
microphone.
everybody?
Sue's about to press her microphone, so I'll let her answer, but
Okay,
I believe it falls on the town as a whole. You're acting as a volunteer board. And again, you're.
man, I've been called into court where I didn't understand why I was there before. Well, that too.
So if you wanna expand on that.
I was actually gonna say exactly what he said. I would be more comfortable. We actually asked an attorney, but it's but from what I've heard through the years, from speaking with our attorney, you are volunteers. Your liability only goes so far.
And we don't know.
No,
Yeah.
you are, as I understand it, you are not personally liable.
And you're not acting as individuals, you're acting as a board, as an entity created by council, created by the town.
I would
But
think
it
if you
is-
went out and above and you put your hand in at helping them get it, you know, you did something illegal or whatever, you probably are, you know.
Conflict of interest, you know.
Not disclosing
involved,
site
not
visits,
disclosing
yeah.
Stuff would not be very wise because it creates a mess.
I was just curious.
I have
Sure,
one
Gene,
quick
you're up
question.
First to be sued.
Sorry.
I
Yeah,
have
Jim.
one quick question before we go. If I understood from sitting in meetings before, don't you usually ask the board, does any of you have prior knowledge? Right.
Yes.
Well, sitting on this board, and I'm also on the planning board, how would I answer that? Because I'm probably gonna have, if something comes up all the way through, I do have prior knowledge.
It depends. I would say it depends, you know, a lot of the special use permits, just based on how our ordinance process is laid out, that go before the planning board are usually major special use permits that go to council. So I'd have to read through it all. I don't know the exact answer off the top of my head, but it's unlikely that you, as a planning board member, would see a project and would make a review and recommendation, and then that special use permit would be passed to this board. Minor special use permits, which are for the lower impact uses, are usually transmitted directly to the Board of Adjustment. I'll just state, there is a provision in the ordinance that if the Board of Adjustment wants an additional set of eyes or an opinion, they can send it to the planning board, but that's not often the case.
We've never
Before.
Well,
done that.
I shy away from that because it muddies the record. And again, I mean, we're looking at the staff level at some changes to these ordinances going forward. And I think something that's important is to separate the decision board from a recommending board, because just like you said, if a project for a special use permit comes before the planning board and council's the deciding authority, members can view that presentation. They just have to keep in mind what they view is not what they should base their decision on, but that's difficult. So in a perfect world, I would think it would be separated, and the deciding board is the only one that has the hearing, the only one that hears evidence and presentations and makes the decision. Yeah.
But Jim, if you ever have, for whatever reason, seen the evidence ahead of time, whether it's as a planning board
Well, I
member or whatever,
understand that.
that's your job to disclose it.
Yeah, I understand that, but I was just thinking somebody might come along and say, well, you knew about all of this from the planning board, you know, but
You disclose it, and if the applicant chooses, he can say, I don't want him in this.
You stated it right after your question. I'm a planning board member and I may have viewed this or have advanced knowledge, and that's all you would have to state. All right, let's run through this last exercise real quick. This focuses less on variances and more on just quasi judicial procedure, evidence standing, et cetera. So the new apartments in the town of Normal, North Carolina, Joe Developer is proposing a new apartment complex. It's an aging garden apartment complex with 74 units currently. He's proposing to tear it down and build a new higher density apartment complex with 200 units. Under the existing ordinance, it requires a minor special use permit, let's just call it, that goes before this board. The property is surrounded by a mix of residential uses, another apartment complex, single family homes, and a wooded area. The applicant for a special use permit must show these are the standards. The project meets these standards consistent with the comprehensive plan, in harmony with the area, not materially endanger public health and safety, not substantially injure the value of adjoining properties. So questions one, before the hearing, in Normal, North Carolina, the Board of Adjustment handles minor special use permits. The new apartments applications on the agenda. Read the actions and statements below. What issues do you see? How could they be resolved? So question one, board member Allen mentioned, quote, our policies and ordinances for apartments are stuck in the 70s. I'm glad we'll get to review the new apartments project and update those standards. What's right or wrong with that, or what do you see?
That's not our job. That goes to town council to update ordinances.
Oh, I see. That's one thing. Anything else?
It's already biased.
There you go, bias, a fixed opinion ahead of the hearing. But you're right. The standards would have to be updated after the fact. Great. B, board member Barber reviewed the application materials, drove to the site, walked around, took down some notes and concerns for consistency with the comprehensive plan. I think we just talked about that. It needs to be disclosed.
But in itself, it's not a problem,
No,
as long as you disclose.
yes, I would say it's again, better to keep it a clean hearing to not visit the site. But yes, if you drive by it every day,
If I drive by a site that happens to be on the
Yes.
agenda every day, I've seen it. While you never drive there and you've never seen it, sorry.
and to protect yourself, you could disclose that. This is more concerned with someone doing an actual site visit, walking around the property. But yeah, it's never bad to protect yourself by disclosing anything. Yeah. During an interview with the local paper, board member Chris states, I can't wait for the new apartments to get built. There's no way that the town can turn it down. It's a lock.
Same as A bias.
Yeah, bias, fixed opinion before the hearing. While chatting with a friend, board member Deborah noted, I was out for coffee with Mr. Neighbor. He lives next door to the new apartments property. He's really concerned about the scale of the project and what it's going to do to his property values. What do you guys think?
Discussing it before you're in the hearing. Right, is that what she was chatting?
Yeah. So she's discussing it before the hearing. And again, going back to standing, the neighbor would have to prove standing, prove property values are impacted, et cetera. All right. Discussion 2, the evidentiary hearing. Through the application and evidentiary hearing, the board received the following evidence. For each piece of evidence, tell me if it's competent, relevant, and substantial. If not, what would make it so? So A, testimony from Joe Developer about why, in his opinion, there will be no significant traffic impacts.
It's not relevant, it's his opinion. Doesn't it? It's not competent evidence.
Not competent. He's not an expert on traffic. B, a letter of support from the minister at Joe Developer's church stating Joe is an upstanding member of the community and volunteers at the homeless shelter.
It's not relevant.
Yep. Text in the application explaining how and why the project meets each standard.
It's not competent. It's
No,
not
Linda.
attributed to a competent person. You've got the application. And he's stating, Joe, is stating in the application, it's gonna meet the standards because 1, 2, 3. He doesn't have to prove them in the application, but he has to prove them in the hearing.
I
Is
see where
that
you're coming from. Yeah, so I mean, in the hearing, you would want to elaborate or provide evidence to
Right.
back up that. But the
But-
application itself is evidence, and as you've seen, usually is the first item in my staff report I submit into the record. So it is acceptable evidence, and showing that he meets the standard. Basically, there's nothing wrong with this one, as long as he provides evidence to back it up in the hearing. D, a petition signed by 25 neighbors opposing the project because it's out of character with the area. But you're right, what Eugene and Heidi said, it doesn't matter the amount. If they haven't proved standing and if they don't have evidence in the record, it can't be considered. Testimony from a neighbor who's a realtor and appraiser about how the new apartments will injure her property value.
Well, she's an appraiser.
She's an appraiser though. And not all these have perfect answers. It's just to get the mind thinking.
What would be-
And I think you're
Yes,
right.
but-
In an ideal world, you would want a third party appraiser. But if she presents credentials, she could be considered an expert. But again, she would need to prove standing. Yeah, but with all those other factors. So F, testimony from Mr. Neighbor that he will be able to see the new apartments from his back porch, which will negatively impact his property value. Opinion not backed up by evidence. Merely stating you're close and merely stating it'll hurt your property values is not enough. G, testimony from Mr. Neighbor about other apartments in town owned by Joe Developer. The maintenance in the other apartments is really lacking. We can't have that kind of blight in our neighborhood. Yeah, opinion, hearsay, not backed up by evidence. Last page, discussion 3, making the decision. Board member Hank hates to ruffle feathers among the neighbors. Let's just table this discussion and see if the neighbors can work it out, or let's at least take a recess so we can talk about this in private.
Ooh.
There we go. All deliberations must be made in a public hearing.
I like the first part.
The table, it's gonna
No,
go
no,
back.
no,
and-
no. Table discussion to see if the neighbors.
Can they, I'm looking at you soon. What,
I know you're looking at me and,
could they request a table for something like that? I think only if the party withstanding requested it.
I think maybe if the parties show willingness
Yeah.
to talk, you could recess
Mhm,
and when they come back, see if they've,
mhm.
if they've sorted something out, but it still doesn't, whatever they sort out still isn't evidence for you to
Mhm.
consider.
Mhm.
The only thing they could be really sorting out would be potential conditions,
Mhm.
something that you could consider as conditions, but would not have to do. Well, if the two parties developed this list of conditions, then you hopefully wouldn't need opposing testimony. But I'm acting as a lawyer here. I'm a little uncomfortable.
It's a possibility. I wouldn't recommend it. And again, only the person with standing should have the power to petition the board for more time. B, board member Jane stated that she is concerned about the legitimate land use impacts on the neighbors and thinks conditions are needed. In addition to the vegetative buffer, a condition recommended by staff and consented by the applicant, Jane recommends we need a condition to limit who this applies to. Something like this special use permit is only valid while Joe developer owns the property. What's right or wrong with that? You got it. Special use permits are a land use approval that runs with the land, no matter who owns the property. Board member Carl stated Joe provided evidence that he meets the standards. While I am sympathetic to the neighbor's perspective, we are legally bound to grant the special use permit. What's right or wrong? It's right. Yep. The board voted unanimously to approve the special use permit. The next week, the town planner wrote a letter simply stating your special use permit's approved. Preliminary minutes from the meeting are attached. This gets probably outside of your purview, but what's right or wrong with that? Bert should know this.
You need to sign the order, yes.
The approval can only be in the form of an order granting the permit. Yes, no, it is, yeah. I won't do that, don't worry. That's all I have. I won't lament this anymore, but thanks everyone for sticking with us. As I said, as time allows, I'll update some of these other things, but I would highly recommend use this variance decision tool. I did update this, so it can be used in upcoming hearings. I'll commit to having that ready for you.
Yeah, I've made some notes. I'll
Yeah.
make sure he has them. We'll let him update that. And I'm gonna clarify one thing I said earlier. Another reason we've not really discussed standing is that through the years as case law has been heard, what we're looking at has become more refined.
Thank you. We do, I think Sue's gonna talk about this, but we do have a special meeting called for
May
May
10th,
10th.
reminder, May 10th. I
Um,
think you're out of town.
Oh. We do have 2 variances now.
She's in Ireland. In June,
on
okay.
2
Yes, we have
May
2
10th,
variances for May
Tuesday
10th.
at 7. We have 2 variances that
I'll be out of town too then.
I have that.
are.
Yes, we had already sent that out to you, but it's a reminder. Yes.
Thank you all, though. That's all I have.
Thanks. Good night, everyone.